In the last occasion, Mr. Shannal has initially taken a point that the qualification with regard to TET of these applicants is little cloudy, and according to Mr. Shannal and reading with the judgment of Devesh Sharma, that we do not have any locus with regard to the qualification of TET. Lord, I'll satisfy your lordship, Lord, first that point that I do possess TET certificate, and the TET certificate and the certificate issued by the board itself has never been recalled, and by operation of the judgment, the same judgment, it cannot go. On the other hand, my submission is before your lordship that the Devesh Sharma judgment has rather substantiated my claim, and my TET certificate cannot be touched. The subject lordship kind sanction, Lord. I'll be on the last occasion, Lord. Did I hand over, Lord, the Devesh Sharma judgment? If not, Lord, I'm giving a fresh copy to your lordship, because
it is here. It is here. How many times will be?
The paragraph may not tally, Lord. That was the reason, Lord. Your lordship is.
It is here.
It is. Now, your lordship, Lord. Now, essentially, Lord, the Devesh Sharma's judgment was on the point, Lord. It has carried out from the judgment of the Honorable Rajasthan High Court, and which, Lord, has strike down and declared the notification of Lord 18 June 2020, Lord, as ultra virus. 2018, Lord, as ultra virus. Now, the Honorable Supreme Court, while dealing with, Lord, the judgment of the Honorable Rajasthan High Court, Lord, has came to a finding that yes, the notification in turn is not in consonance with the established rules and procedure, and that cannot be sustained. Now, Lord, I was, at the cost of repetition, Lord, I was saying before your lordship, Lord, that date of the judgment would be relevant because of the reason all these procedural aspect with regard to my qualification, with regard to TET, and my certificate issuance by the board for qualifying TET is prior to the judgment. This judgment, Lord, of the Honorable Supreme Court in Devesh Sharma, Lord, came in the month of August 2023. Your lordship would kindly take note of the date. Mr. Shannal has also referred, Lord, the date. The date is, Lord, 11th of August. Your lordship would kindly take note of that. But I'll be placing, Lord, few paragraphs, Lord, from that judgment, which, Lord, subject to lordship kind sanction.
11th August.
11th August 2023. Now, Lord, the judgment was not placed, Lord, in entirety, but however, the finding with regard to, Lord, the striking off or, Lord, declaring the notification as unconstitutional, that particular paragraph was placed. But with the leave of your lordship, Lord, I just want to place the rest of the paragraphs, Lord, in the concluding part of the judgment passed by the Honorable Supreme Court, Lord, in Devesh Sharma's case. Your lordship would kindly paragraph 80. Your lordship would kindly take me. That this is conclusive in respect of the persons who has appeared with B.Ed degree and the action taken in the interim period. Lord, we need to read, Lord, the judgment in a as a whole, Lord, not in a secluded part. Lord, your lordship would kindly, I just read paragraph 80. Having made the, Lord, determination, Lord, we all the time are also of the considered opinion that the state of Rajasthan was clearly in error in not calling for applications from B.Ed qualified candidates for the reasons that till that time, when such an advertisement was issued by the Rajasthan government, B.Ed candidates were included as eligible candidates as per the statutory notification of NCT, which was binding on the Rajasthan government till it was declared illegal or unconstitutional by the court. The Rajasthan High Court has rightly observed as under in paragraph 48. And I am also carrying the judgment of the Rajendra Singh Chotia. We are of the opinion that the state government could not have ignored the notification while inviting applications for REET, even like TET, Lord, in West Bengal. Even if the state government was of the opinion that such notification was unconstitutional or for any reason illegal, the same had to be stayed or set aside by a competent court before it could be ignored. Now, this was the finding. Now, the next paragraph is more important. Paragraph 81. What the Rajasthan High Court had stated above is the settled legal position. In a recent three-judge judgment of this court in state of Manipur versus Surya Kumar Okram, this position that a statute, your lordship would kindly take note of that particular sentence. This position that a statute which is made by a competent legislature is valid till it is declared unconstitutional by a court of law has been reiterated. Now, my lord, the finding of this judgment of Surya Kumar Okram, Lord, I'll also place because the sole contention of Lord, my submission before your lordship, Lord, the day on 11th August 2023 should be the cut-off date, and the Honorable Supreme Court has reiterated that on and from 11th August 2023, the notification has no effect. Now, Lord, the question may arise that what would be the
No,
effect?
then in
Lord,
that event, there was no occasion to file any clarificatory application.
I'll come, Lord. I have explanation and I'll try to impress your lordship, Lord. This was pertaining to the person who has already been recruited.
No.
Now, Lord,
if
these
your,
two
if your
paragraphs.
analogy is accepted by this court,
Lord,
in that event, those persons who were already appointed would not have filed an application for clarification.
Lord, your lordship would kindly, Lord, today, at present, Lord, your lordship would kindly appreciate one aspect that at
What was
present,
that?
Lord, we are also having Lord D.El.Ed degree. So, Lord, this is pertaining, which is
Yes, yes.
directly affecting, Lord, my eligibility criteria. Now, Lord, so for TET is concerned, Lord, there is no guideline that who can appear for the TET and all. But in the notification, Lord, they have said that persons having B.Ed qualification can appear. But the board till date has not come up with a clarification that these candidates who have appeared in B.Ed with B.Ed qualification, their TET certificate has been cancelled. Now that is not there. On the contrary, Lord, I'll show in course of my argument that they have accepted this and they have acted on it. So, Lord, that's the reason, Lord. So, for the clarification part is concerned, Lord, this paragraph 80 and paragraph 81, Lord, is the clarification in respect of the effect. Now, that was, Your Lordship is. I'll place that. I'll place, Lord, that paragraph 8 of the clarification also, Lord.
Yes.
Now, this paragraph 80 and 81 makes it clarify. It is very, Lord, expressive in the language that the effect of the notification is stalled or, Lord, ceased from the date of delivery of the judgment. Lord, your lordship would kindly allow me to place, Lord, Surya Kumar Okram's judgment. ওই যে জাজমেন্টটা দেবেশ কুমারের রিলাই করেছে সূর্য কুমার ওকরাম ওইটা
আচ্ছা
this is reported in 2022 oh this is reported in 2029 is 2022 sorry 2022 আমি অ্যাডভান্স 2022 19 SCC 723. Lord, the challenge was before the Honorable Supreme Court is with regard to, Lord, a saving act, Lord, which was repealed prior to that, Lord. I will not be troubling your lordship, Lord, with the whole judgment and factual aspect of the case. But since the Honorable Supreme Court, while dealing with Devesh Kumar's, Lord, in paragraph 81 has dealt, Lord, why the Honorable Supreme Court has taken that particular view, Lord, I will just place, Lord, that particular paragraph, which is at, Lord, paragraph 39 of the judgment. Now, Lord,
yes
Your Lordship would kindly take, Lord, the effect of, Lord, the principles that can be deduced from the law laid down by this court as referred to above are 39.1 is a statute which is made by a competent legislature is valid till it is declared unconstitutional by a court of law. Lord, I'm pausing here for a second, Lord, because of the reason till Lord 11th of August 2023, the notification of 18 June Lord was valid because it was not, this has not been declared ultra virus. This was in force. Now, subsequently, by a judgment of the Honorable Supreme Court, the notification has been struck down. Now, it was valid till Lord 18.8. But any action taken in the meantime, that has been protected in the, your Lordship would kindly take Lord 39.2. After declaration of a statute as unconstitutional by a court of law, it is non-est for all purposes. It ceases on that day. Like it cannot be said, Lord, I'll come, Lord. 39.3, Lord. In declaration of a law, the doctrine of prospective overruling can be applied. Lord, that's the Lord spirit, and that was the reason, Lord, while the Honorable Supreme Court subsequently dealing with Lord, the scope of the judgment has come up with a clarification. Lord, we, as I said, Lord, we need to read Lord conjunctively. Lord, we cannot disjunctively read Lord the judgment says this, and since the explanation is this, so you did not have any right. So, Lord, in a conjunctive reading of the judgment of Devesh Kumar, along with these judgments, which is the constitutional bench judgment, and framed the law with regard to the applicability of the striking down of a particular statute or Lord rules. Now, Lord, this 39.4 says, may I, Lordship would kindly take note of 39.3 also, Lord.
Yes.
Relief can be molded by this court in exercise of power under Article 142 of the Constitution, notwithstanding the declaration of a statute as unconstitutional. Lord, these are the four laws which is governing the field.
Yes.
Now, Lord, we cannot say as on date that the pursuant to the notification, whoever has appeared and cleared their TET examination, that cannot be questioned at this point of time because the Honorable Supreme Court, while deciding Devesh Kumar in paragraph 80 and 81, has clarified that the effect of the judgment would be from 11th of August 2023, not before. So the all other subsequent observations, previous observations, because my learned senior friend has also referred, the applicants has also referred, few of the orders of this honorable court, where this honorable court has declared that this should be subject to the result of the Devesh Kumar. The result of Devesh Kumar's judgment is in my favor. It's not that the Devesh Kumar's judgment has excluded me from every right. Rather, it has taken care and protected my right, and it said that since the effect of the judgment is on and from 11/8/2023, and subsequently it has also been ratified that it is prospective in nature. Now, Lord, again I say, Lord, we cannot read it in a piecemeal. Now, Lord, I'll also place the clarification part also. Now, after this judgment and after this observation, it cannot be said that my TET qualification and appearance in the TET and the issuance of certificate by the board has any cloud at all. Now, Lord, so for the clarification given by the Honorable Supreme Court in Devesh Kumar, Lord, this clarification came, Lord, in the month of April 2024. Yes. The paragraph 8 by London senior friend has also placed. Now, Lord, the law is well settled that, Lord, retrospective and otherwise stated. Lord, I take exception of, Lord, paragraph 80 and 81, and I say that any action taken prior to, Lord, 11/8/2023 has been protected by the Honorable Supreme Court in Devesh Kumar's judgment. citing a Lord constitutional bench judgment that the effect is on and from Lord 11/8/2023. My Lord, দেওয়া আছে তো? Now, Lord, so far the clarification is concerned, Lord, your Lordship would kindly take Lord paragraph 6, paragraph 3 first, Lord. Yes, sir. সূর্যকুমার ওকরামটা, হ্যাঁ স্যার, সূর্যকুমার ওকরামটা পেয়েছেন স্যার আপনি?
না, ওইটাই বলছি 2022-19
Kindly give me a second, Lord. Your Lordship would kindly take, Lord, paragraph 3 first in the clarification which was filed by now, Lord, the application was essentially, Lord, paragraph 3, Lord, your Lordship would kindly take of the clarification judgment, Lord. Paragraph 3, it says, now an application has been taken out by the state of Madhya Pradesh, labeling it as an application for clarification, and the applicant seeks for us to hold that the said judgment ought to have been prospective application only. Now, this was the point of consideration before the Honorable Supreme Court, whether the judgment should be prospective in nature, because it was not expressly said. However, there were observations of paragraph 80 and 81. Now, in answer, Lord, to this application, the Honorable Supreme Court, Lord, says, the Lordship would kindly straightway come to paragraph 8. As it appears that a large number,
Yes.
as it appears that a large number of candidates with B.Ed degree had already been appointed on the basis of a eligibility criteria specified by the educational authorities. Lord, I take a pause here. Now, Lord, the appointment with B.Ed candidates and the qualification of TET with B.Ed, your Lordship would take this as synonyms, because the TET examination with regard to the state eligibility test, there was no argument advanced, there was no whisper at all, and this particular issue can be equated, the qualification of TET can be equated with the appointment only, because there is no separate observation, there is no separate pleadings to that extent. So, Lord, the Honorable Supreme Court was quite aware that any action taken, because there is an expression in paragraph 80-81, the cue is from paragraph 80-81, and that is the reason, Lord, the Honorable Supreme Court is said that I'll can as it appears that a large number of candidates with B.Ed degree had already been appointed on the basis of the eligibility criteria specified by the educational authorities, we do not think it to be equitable to effect their removal. So, the equity which has been created in our favor was also integrated part, Lord, in respect of deciding the appointment, recruitment of the B.Ed candidates, Lord, in the time while this clarification came. We accordingly hold that the judgment delivered by this bench on 11/8/2023 shall be prospective operation, full stop. So, this is a sentence, Lord, which says that the operation of the judgment will be prospective in nature.
Then the next sentence is,
No, I'll come. Now, Lord, this clarification with regard to, Lord, the recruitment, as I said, Lord, your Lordship will not find a single averment, pleadings or discussion with regard to the, Lord, TET qualification. This is all about recruitment. Now, Lord, your Lordship has by this time seen
in the clarification, it says that the prospective effect of the order will be applicable in case of persons who were appointed. If we go through the entire paragraph, in the last sentence, it says, suppose your case is you are about to appear. The court has
No.
also clarified.
No.
Let me put it, then you can answer. Mere selection of such candidate Now there is a selection. One person was appointed, court protected him. Court also clarified that mere selection of such candidate or their participation in the process will not entitle them for the benefit under our present order.
This is recruitment. Lord, I said, Lord, the recruitment with regard to Lord B.Ed candidate.
But see, the
Now,
persons who have participated in selection process, they are also not protected under that order.
did
The court clarified that who has been appointed, I give them this leverage of having its prospect. And in one sentence, I will just refer to page 7 in the given facts. In the given facts, we find that the question as to whether a judgment will be prospective or not was not stated by us in the judgment delivered on 11th August 2020. Now it starts with a sentence, ordinarily a judgment acts retrospectively unless it is specifically stated to be otherwise. So in Devesh Kumar, court did not say that it will be prospective. Now it clarifies that ordinarily it is retrospective unless it is stated. Now it states that it is prospective in case of persons who were appointed.
Now, Lord, your Lordship would kindly take note of that, Lord. In the said Devesh Kumar, that is the reason, Lord, at first place, I have placed paragraph 80 and 81. That has qualified, that has taken care of my right. Because the only one observation in respect of the B.Ed candidates are in paragraph 80 and 81. The court affirms the finding of the Honorable Rajasthan High Court in respect of non-calling of the B.Ed candidates in participating to the recruitment process. So, that window with regard to participating in the recruitment process was open till the date of 11th of August 2023. So that was not done. That has been deprecated by the Honorable Supreme Court. And the Honorable Supreme Court, taking note of that, says that they ought to have been called. I qualify there in paragraph 80 and 81. So the clarificatory part with regard to, Lord, recruitment is concerned, because there are two phases. Lord, I'm trying to impress before your Lordship, TET is one thing and appointment to the post of primary school teacher is a different thing. TET is a qualification to appear in the recruitment. So this is all about recruitment in Devesh Kumar's clarificatory judgment. So it's not about qualifying, Lord, in TET. So far, participation is concerned, Lord, there are two phases. One is participation. One is participation in respect of, Lord, in the presence of the recruit notification, and the another one is participating in, Lord, the recruitment process and thereafter being selected or not selected. So we need to segregate, Lord, two parts, because the first challenge was by Mr. Shannal that I am not a TET qualified candidate. So in answering that question, Lord, I beseech your Lordship, Lord, to take note of paragraph 80, 81 and the principle of prospective, Lord, applicability of the judgment. Because judgment has taken care of. The prospective applicability is in respect of the person who has already been appointed. And two issues, TET qualification and recruitment process, are different. Because it is a minimum qualification.
Yes.
Because that is, I cannot claim my right of recruitment based on the notification. Because, and this, your Lordship has stated, Lord, that the mere selection of such candidate of their participation in the process will not entitle them for a benefit under our present order. Now, Lord, I'll explain that. Lord, your Lordship would kindly allow me to place the whole paragraph 8. It says, Lord, we accordingly hold that the judgment delivered by this bench on 11/8/2023 shall have prospective operation. Full stop. But
this I have understood. that if you read Devesh Sharma and Sukram together conjointly, it gives a prospective effect.
Obliged.
Correct. This is what you are trying to
Done.
impress upon. Now, what about this sentence? How do you clarify that ordinarily a judgment acts this in the clarification order in Devesh Sharma? The court says that ordinarily retrospective. Now, retrospective goes back to 2018 when the amendment was put in vogue.
No, it says blood prospective operation.
No. Given facts, the clarification order in page
Yes.
7, ordinarily a judgment acts retrospectively. The court has in the first judgment it says Sukram.
With greatest humiliation.
Now,
Lord,
after when the application is filed by Madhya Pradesh High Court, Madhya Pradesh State of Madhya Pradesh, this clarification comes in clarification. It says that ordinary judgment acts as retrospectively. Retrospectively goes back to 2018.
Lord, that is the reason, Lord, I said, Lord, subject to kind sanction, Lord, we need to read the clarification conjunctively with the finding of the original judgment. The original judgment, Lord, if your Lordship kindly allow me again, Lord, I can place paragraph 80 and 81. Because paragraph 80 and 81 came on the in the month of August 2023, 11th August. There, the right of these persons who have appeared with the B.Ed qualification has already been protected. They have not been thrown out, because that's the spirit of the Devesh Kumar judgment. Now that is, and the Honorable Supreme Court, while dealing with Lord, the right, has relied on a judgment of the Honorable Supreme Court, which now that is the reason, Lord, I was trying to, Lord, submit before your Lordship, Lord, that we should not, Lord, read it conjunctively. Should read it, Lord, conjunctively. The paragraph 80, 81 and, Lord, the clarification. How can we ignore, Lord, subject Lordship kind sanction, the paragraph 80, observation of paragraph 81 and 80? May I just place it again for your Lordship's convenience, Lord? Kindly, Lord. Lord, may I just read it again for your Lordship, Lord?
ক্রিমিনাল লয়ারদের লিখতে আসছে কাল মামলা মিস করেছে
আজকেও করেছি। Having made the above determination, Lord, the determination is that the notification is, Lord, unconstitutional. We all the same are also of the considered opinion that the state of Rajasthan was clearly in error in not calling for application from B.Ed qualified candidates, for the reasons that till that time when such an advertisement was issued by the Rajasthan government, I will be beseeching your Lordship to read, Lord, that the board or, Lord, the state of West Bengal, B.Ed candidates were included as eligible candidates as per the statutory notification of NCT, which was binding on the, your Lordship would kindly read this as, Lord, state of West Bengal or board, till it was declared illegal or unconstitutional by the court. The Rajasthan High Court had rightly observed as under. We are of the opinion that the state government could not have ignored the notification while inviting applications for REET. Your Lordship would kindly read date. Even if the state government was of the opinion that such notification was unconstitutional or for any reason illegal, the same had to be stayed or set aside by a competent court before it could be ignored. So the right accrues here in this paragraph. That it has been taken care of by, so subsequent clarification, as I said, that is only to the extent that the person who has already been recruited by the particular state. আপনি বলছেন না কেন? আমি
বলছি না যে তুই এক জায়গা থেকে পড়ছিস তো এসব অনলাইন হয়ে গিয়ে প্রবলেম
হ্যাঁ, এটা এসসিসি অনলাইন, এটা now, Lord, the paragraph 81 is supplementing, Lord, paragraph 8. Lord, may I just read it again for your Lordship? Lord, that's my case. It states,
read it.
Lord, now this is the, Lord, these two paragraph has decided my fate. The clarificatory part is only to the extent of the person who has been recruited. Now there cannot be, Lord, ambiguity, Lord, in the finding, because the Honorable Supreme Court was cautious that by this time many things has happened. So not only, Lord, the candidates who are having B.Ed qualification has been protected, including the person who has been appointed, they have been also, Lord, protected. We cannot, Lord, take it as a piecemeal. We need to read in seriatim. 80, 81, then blood paragraph 8 blood the clarification. If you read blood in seriatim, blood it protects blood the person who have applied, because the any equity blood created before blood the notification was struck down by the Honorable Supreme Court, that cannot be taken out. That was the spirit even in the explanation given in paragraph 8. The equity created. Lord, here I am also not standing on the same footing. Now, that was the reason, Lord, I was beseeching your Lordship, Lord, to read. Or
5 মিনিট আর নিবি তো?
আপনি জান আমি 5 মিনিট কেন আরো একটু সময় নেব, আপনারই কতগুলো করা অর্ডার।
Just I'm taking 5 minutes time.
Yes, next.
So, Lord, this cannot be said, and in the garb of this judgment, the finding is in my favor. It's not that it is excluding my right of participating in TET and qualifying for the recruitment process. And it is the board who has acted on this notification, on this judgment, and thereafter have issued the TET qualification certificate. Now, till date, as I said, Lord, in my opening submission before your Lordship, that till today, in the board's website, Lord, it is appearing, all the candidates, Lord, TET qualification certificate is appearing, and anybody can log in and download the certificate. The certificate has not been recalled by the board itself. So, Mr. Shannal appearing for the board cannot come and say that these people are not TET qualified, so their primary eligibility is not meted out. So, in that score, Lord, I beseech your Lordship, Lord, these are the report and supplementary. It's তোমার কিছু করেন না, দাঁড়িয়ে করো, উপায় যাও। Now, Lord, this was, Lord, this is my submission in respect of, Lord, the judgmental effect of, Lord, Devesh Kumar's judgment. Now, Lord, there are few factual aspects, Lord, in response to Mr. Shannal's, Lord, argument that the terms of the board placed before the court and the submission made by Mr. Shannal is little contradictory. In a recent, Lord, proceedings where Mr. Firdaus Samim appeared for the petitioner in WP number 5122 of 2024, Lord, where a similar kind of, Lord, issue, a connected issue, Lord, was raised, where the board was directed to file a report. The report was made available to Mr. Firdaus Samim. I know Mr. Samim will be little hesitant, but the order observed and the copy of this such report we have got it. Lord, your Lordship would kindly take, I just supply, because since it is not been, I was not party to the proceedings and I'm relying on a document which has been placed by the board. Now, that is the reason, Lord, I'm referring the order, Lord. The board is directed, Lord, it is in this. তোরা appear করেছিস তুই নিজেই, it is internet, so please take it. WP number 5122 of 2022. দেখাচ্ছি তোমাকে। WPA 5122 of 2024. Shubhranshu Pathak and others versus the state of West Bengal and others. The petitioner has
5122 of
2024. Lord, your Lordship would kindly take these three orders. I just read it for your Lordship and for my friends also. Ene eta copy ene baba. Petitioner had participated in the second paragraph, Lord. Order dated 5/11/2024. Recently, Lord, 1 year back. The petitioner have participated in the TET 2022 conducted by the board education with B.Ed and D.El.Ed from now this is B.Ed or D.El.Ed. The Honorable Supreme Court in two successive decision in the case of Devesh Kumar Sharma reported in such and Jaivir Singh is Lord NIOS, so Lord I'm not saying it, was held that B.Ed is not an eligible qualification for appointment as a primary teacher. So the 18 months diploma conducted by NIOS through ODL mode. The petitioner are claiming that they are also possessing 2 years regular diploma in elementary education from the board and are paying that their eligibility to get the appointment as primary teachers may be tested on the basis of their said diploma. The board is directed to file a report on the said prayer of the petitioners on the next date of hearing. Now, this was the direction given by the court, and thereafter, a report was filed. Now, this is the report filed by the board. আরে ভাই তোদের কপি তোদেরকেই দেবো
হঠাৎ বলছি না তাহলে বললে বার করে আনতাম ফাইল থেকে বলে দিই না কেন ওভার ফোন যেটা দেখাবো দেখা
Let me I just I've got one extra copy, so please take one.
দে একটা দিই
Then may I just place with regard to that, Lord, query of the court, what is the terms of the board? Lord, it says, Lord, I'm first part, Lord, I'm skipping over because that's the compliance. Lord, may I read it? By order dated 5/11/2024 passed in WPA 5122 of 2024, Subhrangshu Pathak, the Honorable Justice Vishwajit Basu directed West Bengal WBPE to file a report on the said prayer for petitioners on the next date of hearing. The petitioners are claiming that they are also possessing 2 years regular diploma in elementary education from the board and are praying that their eligibility to get the appointment as primary teachers may be tested on the basis of the said diploma. Certain dates considered by the board to be relevant pertaining to the claim of the writ petitioner as stated infra. 29/9/2022 TET 2022 notification was issued by the board, thereby allowing B.Ed trained application to sit in the TET 2022. 18/10/2022 in Ujjwal Haldar's case, which has been placed before your lordship, Lord, on the last occasion. Such and such notified shall abide by the result of the SLP such and such is appended with this report. 7/11/2022 in view of the above order dated 18/10/2020 it was notified by the board that B.Ed candidates applying for TET will be allowed to appear in the teacher eligibility test 2022 subject to final result of the Honorable Supreme Court. The final result of the Honorable Supreme Court is in my favor, not against me. The report also says that. That's the stance of the board. 10/2/2023 TET 2022 result was declared. Many candidates who applied in TET 2022 B.Ed did also pass out. 29/4/2023 TET 2022 eligibility certificates were issued to the TET 2022 pass candidates. 11/8/2023 the judgment, Lord, Honorable Supreme Court of India in Devesh Sharma versus such and such unequivocally held that the B.Ed is not a proper training qualification for being considered for the post of primary pan-India. 13/2/2024 in Shilpi Sen's matter, in paragraph 5 to 12 direct infra, which Lord, the applicants has referred. Now, Lord, in the order has been quoted. Then paragraph 3, the candidates passed in TET 2022 with B.Ed training qualification may be considered as TET 2022 passed candidate. Lord, may I just paragraph 3, Lord, bottom in say paragraph page 2. The candidates passed in TET 2022 with B.Ed training qualification may be considered as TET 2022 passed candidate since the candidates were already declared as TET 2022 passed candidate before came into force for the order of the Honorable Supreme Court of India on 11/8/2024 in Devesh Sharma's case. So, this is the such and such has not specifically stated about the value. What I'm saying, that is what my argument is. Came into force of the order of Honorable Supreme Court in India on 11/8/2024 in Devesh Sharma's case. And the Honorable Court, in its judgment dated 11/8/2023, has not specifically stated about the validity of a TET pass candidate with B.Ed training qualification. The West Bengal Board of Primary Education, being the examining and recommending authority, will verify the eligibility of a candidate for being recruitment as a primary school teacher at the time of scrutiny and verification under the recruitment process to be notified as and when required as the NCT norms and solemn order of the Honorable Supreme Court on such and such. If the candidate fulfills the eligibility criteria at the time of recruitment notification as per NCT norms, they will be allowed to participate in the recruitment process. Lord, I am saying that the argument, Lord, advanced before your Lordship today by me, and the advancement of argument by Mr. Shannal is in variance because of the reason this is the board stance before a competent court of law. Now Mr. Shannal comes and challenges, Lord, the now, Lord, your Lordship would this is the stance of the board, because this report has been filed by the secretary of the board, and Mr. Bishas was also, Lord, appearing in the matter. Mr. Atul Bishas was also appearing. No, I'm not saying. I'm saying that my TET qualification cannot be challenged. Lord, I have not come to the level of, Lord, recruitment. So for eligibility criteria with regard to recruitment process, Lord, I have also answers. So, Lord, this is only pertaining to, Lord, TET qualification. Lord, your Lordship would kindly take, Lord, the supplementary affidavit, Lord, which I have given on the last day, with this I have served upon, Lord, the board as well as, Lord, the applicants. Lord, may I just explain the documents, Lord, which is annexed, Lord, on and from paragraph page 4. This is the TET certificate. The first annexure is the TET certificate of the applicant. Top, Lord, teachers eligibility TET 2020. Lordship has got, Lord, 2022. Lord, he is qualified. Remarks, Lord, as qualified. Now, Lord, the next is page is 5, which is the primary teachers recruitment form, Lord, where I am seeking, Lord, liberty to participate, and because of my result has been withheld, so that is the reason, the first prayer I have come and wanted to fill up this particular form. Now, Lord, it says about, your Lordship would kindly take, Lord, the training qualification.
Yes.
Third, Lord, first is personal details, second is academic qualification, the third is training qualification. Name of the examination, 2 years diploma in elementary education, state, West Bengal, examining body, board, session 2022-2023, which is, Lord, I am 2023-2025. Now, Lord, year of passing 2024, full marks such and such, obtain such and such marks. So, Lord, this is the form he has filled up based on B.Ed degree, passed the TET examination. Now, Lord, your Lordship would kindly come to page 6. The forms in respect of TET examination, which was held in 2022. Now, the first is personal details. Then is, Lord, your Lordship has got, Lord, academic details. Then, Lord, training qualification. Your Lordship would kindly take, Lord.
You're reading from which?
Lord, page 6. Paragraph 4 is the TET, page 4 is the TET certificate, 6 is the form which I am intended to fill up, and the next page, page 6, is the, Lord, TET form. In 2020, the way, Lord, I have filled up the form. Name of the examination in the training qualification, your Lordship would kindly take, Lord. First is personal details, second is academic qualification, third is training qualification. In the training qualification, your Lordship would find, Lord, the left name of the Bachelor of Education, B.Ed, West Bengal, then, Lord, Bardhaman, and then, Lord, session of B.Ed, then when, Lord, passed, then year of passing 2019. So this form to show the queue that the person with B.Ed qualification appeared in TET, passed TET, board has taken a chance that already the person, and then in page 5 I have shown in this recruitment process they have been allowed to fill up the forms. So my contention is that you are allowing the person to appear in the examination with TET qualification of 2022 with B.Ed degree and subsequently D.El.Ed degree course. So, Lord, you cannot throw me out, and this would be a clear violation of Article 14 because you are treating the equal with unequality. Because this is one candidate, I can show there are many, I guess. There are a number of persons who have been allowed to participate in the recruitment process based on the TET certificate of 2022. So, this question with regard to that I do not hold the minimum eligibility criteria of being passed in TET does not stand. One, to sum up, to one, the effect of the judgment, which is to be read in the positive aspect, and the Honorable Supreme Court has given explanation. Two,
Yes.
That the board has taken a chance before the Honorable Single Bench in a pending proceedings and filed a report that the persons who have passed TET 2022 with B.Ed qualification, they will be allowed to appear, allowed to participate in the recruitment process. And third, the candidates having TET degree of 2022 has been allowed to participate in the recruitment process. So, these are my submissions with regard to TET qualifications. And the most surprising feature is that since our certificate with regard to TET is appearing in the website and in the database, we are allowed to open the forms. We are filling up the forms, but we are being rejected only on the score that our session with regard to D.El.Ed degree has not been completed and our result has not been published. So that's the primary concern. Lord, I say, Lord, to add up, Lord, I say, subject to kind sanction, our result has been withheld only to deprive us so that we cannot participate in the recruitment process. Because the session of the D.El.Ed course is June to June, June to July. In 2023, July it was started. It ought to have been completed in July 2025. We are in the month of November. Yes, I'm sorry, December, first November. But till date, the result has not been withheld, declared. Now, this issue, the board in various occasions takes various stances. In the previous recruitment process in 2022, the board did the same thing. The result was not published. Part 1 examination was concluded. Part 2 was not there. So ultimately, the candidates like us, with TET and D.El.Ed degree. Your Lordship would kindly keep aside the B.Ed degree for the time being because that is only relevant for the purpose of TET. So for this recruitment is concerned, by this time, I have acquired the eligibility criteria of TET qualification and D.El.Ed degree because that's the training I have completed. I've said in my opening submission that I am already completed my course. I'm awaiting for the results. So for the next limb of submission with regard to the eligibility criteria and participation in the recruitment process, I'm making my submission. So I am, as on date, TET qualified and having a qualification of completion of the D.El.Ed degree. Now, on the last occasion when the recruitment process was started in the year 2022, the same thing happened. No publication of the result of the D.El.Ed. Batch of candidates approached this honorable court, but this honorable court directed the board to publish the result, and the board also undertook and submitted before this honorable court that we are publishing the result tomorrow. 29. We'll continue. We'll take this. Let page, in my applications, I have annexed the order, your lordship would kindly take the fifth volume. I have said, your lordship, আমার repetition থেকে বলছি না। 22. Sir, আমারও ভালো স্যার। My lord, your lordship would kindly take note, Lord, annexure P10 622. No, I'm only for the purpose. আমার repetition 622. Lord, this is, Lord, as I've said, Lord, in this matter, I am told that the learned advocate for the West Bengal Board of Primary Education that today, on 29/9/2022, the result of D.El.Ed Part 1 will be declared. And digital mark sheet will be sent to the different institution. Now, this was in respect of Part 1, but here in our case, we have completed Part 1, appeared in Part 2. Result is not being published. We have completed the course. All the persons who were undergoing the course will get the digital mark sheet tomorrow and 30/9/2022. It was further been stated on instruction Mr. Such and such for the West Bengal Board of Primary Education that TET qualified candidates who are undergoing D.El.Ed training session 2022 and qualified D.El.Ed Part 1 2022 examination will be given opportunity to apply in the recruitment process to be initiated by the board. Now, on the last occasion, they have also allowed the ensuing candidate to participate in the recruitment process. That was the consent given by the board. Now, this year, they are very strict and they say, unless you possess a qualification on the date of last date of the filling of forms, you will not be allowed to participate in the recruitment process. Similar this paragraph, he has also submitted that the opportunity will be given to all persons who are undergoing D.El.Ed course of the sessions 2020-2022. Therefore, I find that the grievance of the petitioners is redressed by the stand taken by the board, which is beneficial to all.
Okay.
Similar this order, the other batch of persons who had the requisite qualification and completed D.El.Ed degree, they have challenged the order before the Honorable Division Bench. Now, by this time, the hearing of the appeal could be taken up. In the meantime, the recruitment process was not concluded. It started and the interview was about to be taken. At that juncture, the order of this Honorable Single Bench was set aside by the Honorable Division. The Honorable Division Bench held that the benefit should not have been extended to the candidates who were ensuing the D.El.Ed course. The order was travelled to the Honorable Supreme Court by the same petitioners like us who were in pursuing their. The Honorable Supreme Court decides the issue and answers two questions. One, that it was the incumbent upon the board to publish the result before the recruitment process starts, and two, the cut-off date with regard to the eligibility criteria. Now, your lordship would kindly take that judgment, the writ petition order I have referred at page 622, Lord. This is the order of the Honorable Division Bench. No, the Honorable Supreme Court. Lord, I'm sorry. এটা আমার দাগ মারা আছে। হ্যাঁ সৌমেন পালের সুপ্রিম কোর্টের জাজমেন্ট। It is.
Yes.
Lord, this, Lord, না Lord, the paragraph 2, Lord, the issue involved in this case relates to the appointment to the post of assistant teacher in primary school in the state of West Bengal. This post is governed by the West Bengal Primary School Teachers Recruitment Rules 2016, and the qualifications for appointment to the said post are prescribed in Rule 6, which is extracted below from the ready reference. The next paragraph is also important. In this case, we are concerned with sub-rule 2 of Rule 6. This sub-rule was later amended by a notification dated 22nd of December 2022 in the following terms. And this particular rule was referred by Mr. Shannal while making advancing argument.
না আমি সাইড করিনি
আপনি পড়লেন যে কাট অফ ডেট
No, I have not cited this judgment.
No, you have not, but you have referred the rules. No, that is what I'm saying. Now, Lord, paragraph 4, Lord, it says, as it evident from the above, the minimum qualifications specified in Rule 6 of the Recruitment Rules 2016 will be those that are prescribed by the National Council for Teachers Education, a body constituted under the National Council for Teachers Education Act 1993. In exercise of the power conferred by subsection 1 of section 23 of the Right to Children to Free and Compulsory Education Act, by notification dated 23rd August 2010, the NCT laid down the minimum qualification for a person to be appointed as a teacher for class 1 to class 8. The qualifications are amended from time to time, and the qualifications that were prevailing at the time when the recruitment notification for appointment of assistant teachers primary in the state of West Bengal was issued, were those prescribed by NCT in its notification dated 29/7/2011. The relevant portion of the said prescription is extracted here and below, and the minimum qualification has been given. ভালো একটু দেখে নিই। Now, Lord, paragraph 6, Lord, I'm skipping, Lord, Lord, may I read the whole? In the above referred legal regime governing the appointment to the post of assistant teachers, that the appellant's aspiration and endeavor to join the post advertised on 21/10/2022 came up for consideration. The relevant factual background is as follows.
Yes.
As the mandatory minimum qualification for the post, Lord, it is the same notification in 2022, whatever was the notification, it is just a replica in 2025. There was no change. So for the minimum qualification is also concerned. But as I said, Lord, I was trying to, Lord, answer the question of minimum qualification. Lord, here, Lord, the answer is, as the mandatory minimum qualification for the post of primary teacher in the state is a diploma in elementary education, which I hold today, a 2 year course conducted by the West Bengal Board of Primary Education constituted under the West Bengal Primary Education Act 1973, the appellants enrolled themselves for 2020-2022 batch of D.El.Ed. It was always been the practice that a new batch would commence from the 1st July of a year and conclude by the second successive year, which in the present case would have been 30th June 2022. Well, my case is also like that. The outbreak of COVID-19 pandemic and problems with the constitution and functions of the board delayed in 2020-2022 batch, leading to a situation where the normal and natural conclusion of the 2022 batch by 30th June seemed uncertain. The appellants were concerned that they may lose the opportunity to apply and participate in the recruitment process that was to commence with the issuance of a notification in October 2022. With the apprehension and anxiety about the fact that many of them could cross the age bar if they did not participate in the upcoming recruitment process, they approached the Calcutta High Court by filing writ petition under Article 226, in which they prayed us, Lord, which is akin to our prayer, Lord, that we also, Lord, want to complete and Lord, to publish the result before the last date of the applications, Lord, which is akin, Lord, I'm not troubling with Lordship, Lord, with the Lord prayers of the writ petition, Lord. Now, Lord, there is also a prayer for stay of the recruitment process. Lord, here also, Lord, we have also prayed for stay of the recruitment process till, Lord, the result of the part 2 examination is declared. In the meantime, to obviate the inactive functions of the board, the government constituted an ad hoc committee, and the president of the board took charge on 24/8/2022. Along with the president, the deputy secretary of the board also took charge on 26/8/2022. After taking charge, the officers took stock of the situation and realized that the D.El.Ed batch for the 2020-2022 was already delayed and urgent action was required to be taken. It is evident from the record that part 2 session of the 2022 batch ended on 30th June 2022. In our case also in 2025 it is ended. And the examination for that purpose, part 1 theoretical, was conducted between 15/7/2022 and 18/8/2022, which was anyway far beyond 30th June 2022. That normal conclusion for any D.El.Ed batch. So even if we can also be termed as abnormal because this was ought to have been concluded in July. We are in December.
কোন পরীক্ষা পাস করেছিস 1 মাসের কোর্স শেষ হওয়ার পর?
হ্যাঁ,
কোন পরীক্ষাটা বলতো?
সব পরীক্ষাতে। When the writ petition came up for hearing before the High Court, I take the book of Mr. Shanna. It cannot be a chance that if the examination is taken in one day, obviously the result will come after 10 months. This cannot be a practice. If the action of any statutory body or any state as under Article 12 of the Constitution of India is vitiating right and taking away right and creating hindrance in exercise of the right, that court ought to have taken should take a step, because we cannot accept abnormal things. It's a normal thing that if I have participated and take admission in a course, the result would come within stipulated time, because that's the function of a state, that's the obligation of the state to function correctly, properly, to secure the right of an individual. That's the challenge before your lordship in my writ petition also.
Your notice you indicated on the first date of hearing
My lord.
that they have completed their course, now they are to leave the institution.
Yes, I'll come. I'll refer.
So what
that
was the date of that notification?
the June 30th June. Your lordship, 588. Your lordship would kindly take note of that particular document. Lord, I'm bow down to your lordship.
In normal case, Mr. Sannal, when is the result is to come up? In normal cases, previously also you have conducted D.El.Ed. So if a June candidate completes the course in June,
Malad,
what
I
is the
tell you,
tentative?
lordships, this normally takes 6 months, 7 months
6 to
after
7.
the completion of the exam,
Sure.
because it
But
is
that-
statewide examinations. It has to be checked up, published, everything. Lakhs of candidates. It's not that Malad one of them. It's lakhs of candidates.
Okay. So, that cannot be a normal practice. That's the challenge before your lordship. As I said, the action of the state machinery is dependent on the beneficiary of the people. The state should act beneficially. They cannot take away the right. There, the court intervenes and secures right of the citizens.
Yes.
The individual is protected by the Constitution of India. The state machinery has obligation to perform. Now they cannot take a plea that every year we do it after a year, 7 months, 8 months, 10 months. That cannot be the rule, because the rule says that the course would be of 2 years, and I will be thrown out from the institution, and I'll loiter in the area, but he will not publish my result. That's not the protection of an individual.
So the rule does not specify any specific time period in which the result has to be.
My lord, that is the challenge in the writ petition also. We have prayed for declaration of the result of the examination. That's the challenge here in the writ petition also.
Yes. Next.
Jan? The I'm sorry, Milord, the paragraph 10, when the writ petition came up for hearing before the High Court on 20th September, 21st September 2022, the Learned Counsel for the Board sought time for taking necessary instruction. When the Learned Single Judge of the High Court again took up the writ petition with a petition a week thereafter on 29th September 2022, the counsel appearing for the on behalf of the board, having obtained instruction from the government stroke board, informed the board that the result of the appellant D.El.Ed would be declared that very day, that is 29th of September 2022, and the digital mark sheets would be sent to the different institution. Now they become super proactive. In jet speed, they declare result and it will be sent digitally to everybody, and they will facilitate the person ensuing candidates to appear in the examination. Now this year they do not want, so we have to bear their arbitrariness that yes, this year you don't want, that year you wanted, so you have done it instantly in a supersonic jet. And the digital, the High Court was also informed, please, Mr. Vishwas, do not disturb. The High Court was also informed that the candidates like the appellants who are TET qualified and who are pursuing D.El.Ed course for the session 2020-2022 and had already qualified in Part 1 examination will be given an opportunity to participate in the recruitment process to be initiated by the board under advertisement dated 21st of October 2022. Lord, your Lordship would kindly visualize one aspect. The act of arbitrariness is so apparent that cannot be accepted by court of law. On last occasion, when the recruitment process was initiated, they took a chance that, well, we will allow the pursuing candidate and we will allow the candidates who has only passed Part 1 examination. Because ultimately the recruitment process, when it will be completed, he will also completed the D.El.Ed degree. Now here we are in a situation where we have already completed our course, but we are not being allowed to participate. Now, this arbitrariness in respect of one recruitment process and another recruitment process, which is the present recruitment process, look, they cannot have any explanation. It's not in their based on their whims. There has to be a uniform rule of law. And as I said, Lord, the experience is required. It is only the action of the respondent that they are withholding my result for which I am unable to participate. It's not my education which is steering at. It's not the experience which is not being counted. It is the result. Because I have already participated and completed my course. Now, the next page, in view of the statement made on behalf of the board, yes. On behalf of the board and without any further consideration, the writ petition was allowed and disposed of with the following direction. I have placed that particular order, that order I have given to your Lordship, and I am skipping over that part. On 29/9/2022, the date on which the learned single judge allowed the writ petition, the board issued a notification indicating that the result of the D.El.Ed Part 1 examination held in the month of July for session 2020-2022 is published. And in terms of the said notification, the candidates were allowed to avail post-publication review or scrutiny of their performance within the prescribed time. The publication of the result was also intimated to the various institutions, and the students were permitted to receive the digital mark sheets. The exercise was intended to enable the applicants to candidates to participate in the recruitment process on the same day on 29/9/2022. Yet another notification was issued indicating that the board is going to recruit TET qualified candidates for appointment to the post of assistant teacher in the vacancies that may be indicated. The Intendment of this notification is in the clarification and declaration that candidates like appellants who are TET qualified and had undergone D.El.Ed training and qualified for the Part 1 examination can participate in the recruitment process. It was also indicated that the recruitment notification and application form will be made available on the website with the effect from 21st October 2022. As it was contended by the respondents and the acceptance of the High Court that this notification dated 29/9/2022 itself is the recruitment notification, in order to contrast it with the subsequently issued actual recruitment notification dated 21 October 2022, we have reproduced both of them. Notification of this, the notification has been given where the vacancies were also declared. So, Lord, I'm skipping over this part. Lord, why I'm placing this judgment, Lord, as a whole, because that answers the questions of Mr. Shannal. Mr. Shannal, which has taken, Lord, a plea of cut-off marks, cut-off date, Lord, and says, Lord, on the date of notification, we must post the requisite qualification. This was also being argued before the Honorable Supreme Court. The same argument was advanced by Mr. Shannal, but that was negated, and the court, Lord, held otherwise. Because that is the reason, Lord, I have shown your Lordship in paragraph 3 that the Honorable Supreme Court was aware that the recruitment rules has been amended and subsequently amended rules has been incorporated. Based on that, also this view came. That is the reason, Lord, I'm placing the judgment as a whole. Lord, that answers everything. Now, kindly excuse me for a second, Lord. Following the above referred notification, the recruitment notification was in fact issued on 21/10/2022. Which is in our case, not the subsequent notification in November, 19th November. The board in its submission before the division bench contrasted the previous notification dated 29/9/2022 with the recruitment notification dated 21st/10/2022 and asserted that the latter alone is the recruitment notification. The recruitment notification dated 21/10/2022 is reproduced for ready reference. So, on the last occasion also, in previous recruitment, we have also said that the subsequent notification, which is 19/11/2025, is the last notification for recruitment. But now today in court, the board comes and says, no, the September notification is the recruitment notification. This has also been clarified, that the board cannot take these different turns. But I'm skipping over the notification because this is akin to the November 11, 2025 notification. Now, paragraph 14, it is clear from the above referred notification dated 21st October 2022 that 1. It invites online application for recruitment to the post of assistant teachers. 2. It also specifies that TET qualified trained candidate, including the appearing candidates for the sessions 2022 in D.El.Ed, special D.Ed, B.Ed course will be eligible for participation. 3. It mentions that there are 11,765 vacancies and further notifies that the recruitment shall take place under Recruitment Rules 2016. With this analysis, there cannot be any doubt about 21/10/2022 being the recruitment notification. This controversy must end here. So that's the finding with regard to what would be the notification, recruitment notification. The appellants applied as per the recruitment notification dated 21st October 2022, obtained their course completion certificate on 29/11/2022. And the final result of part 2 of the examination were also declared on 30th December 2022. Interviews commenced in December 2022 and the process was moving towards completion. At this stage, questioning the legality of the order passed by the single judge, the private respondent who possessed D.El.Ed qualification as on the date of recruitment notification dated 29/9/2022, filed writ petition, the earlier notification, the submission of akin to the submission of the applicants who have filed the CAN application. I am not giving you any answer. I am submitting before the court.
Yes. Yes, yes, continue.
Now, my lord, before the division bench of the High Court contending that the appellants are ineligible and their candidature must be rejected. The primary contention was that the appellants did not possess the minimum qualification as of the date of recruitment notification, and that the board could not have relaxed the recruitment rules permitting the appellants to participate in the recruitment process. The division bench of the High Court, by its order dated 27/2/2023, asked the board to file an affidavit indicating the circumstances in which the recruitment process was initiated, as well as the steps taken by the board in conducting 2022-2022 D.El.Ed course. In compliance with the High Court's order, the board filed an affidavit. The relevant portion of the affidavit is as follows. My lord, may I just, Lord, read the relevant portion, Lord? Now, this has been quoted later on, so Lord, I'll place from there. But your Lordship would kindly continue, Lord, with paragraph 17. Finally, the order impugned before us, the division bench of the High Court allowed the appeal and set aside the order of the single bench. The solitary factor that impressed the High Court is simply that, as Rule 6.2 of the Recruitment Rules 2016, as amended in 22nd of December 2020, unambiguously specified the eligibility qualification required as on the date of advertisement. Candidates must possess the eligibility qualification as of the date of the advertisement, 29/9/2022. Firstly, the High Court treated the date of notification dated 29/9/2022 instead of recruitment notification dated 21st October 2022 as the recruitment notification, and secondly, it construed the rule to have prescribed a cut-off date for qualification. In this view of the matter, the division bench proceeded to set aside the later part of clause 3b of the notification dated 29/9/2022, enabling candidates like appellants to participate in the selection process, virtually holding all the appellants ineligible for even participating in the selection process. Lord, the order, Lord, of the Honorable Division Bench was also, Lord, quoted. Having heard the parties and considering the materials placed, this court is of the clear view that the board cannot travel beyond its own recruitment rules. Apropos, the above discussion in 2016 recruitment rules as amended by the notification dated 22nd December 2022 unambiguously specifies the eligibility qualification requires as on the date of the advertisement. The nature of such qualification is also specified by the NCT notification dated 23rd August 2010. The court further notices that the law is well settled on the point which stand also discussed above, that the eligibility qualification must be possessed by any candidate on the date of recruitment notification. It is undisputed that the private respondent in MAT such and such and MAT such and such acquired the minimum eligibility condition of D.El.Ed on 29th November 2022, much after the publication of the recruitment notification of 29 September 2022. In view of such the position, the board could not have created room for the private respondent. This was the observation, saying this, that Lord, the room was extended to them because and considering the first notification as a recruitment notification. This observation was not struck down by the Honorable Supreme Court and said the subsequent notification is to be read as a recruitment notification. Now, Lord,
First date of the notification, which
here, Lord, is 25/9/2025. And the second one is 19/11/2025.
okay. Yes.
Challenging the judgment and order passed by the division bench, appellant filed present appeal. We have heard Mr. P. such and such, such and such, such and such, and also Mr. such and such, and for the board, Mr. Shannal and learned senior counsel for the respondent, and then now the observation is we may mention at this very stage that we have informed all the learned counsel appearing for the persons who have filed impleadment a petition that we will not be entertaining these applications but would allow them to withdraw and avail. Some candidates also wanted to join the cause, and that was the reason. Now, Lord, the interpretation, Lord, paragraph 19, Lord, in interpreting, Lord, the rule, interpretation of rule 6.2 of the West Bengal School Teachers Recruitment Rules 2016, NCT is the statutory regulator for teachers' education. In exercise of its power under Section 32 of the NCT Act, it makes regulations specifying norms, standards, and guidelines. Inter alia prescribe minimum qualifications, and one such exercise in the prescription of minimum qualifications for teachers under notification dated 29/7/2011. The West Bengal School Teachers Recruitment Rules 2016 by itself does not prescribe a minimum educational qualification for teachers. Instead, though Rule 6 of the Recruitment Rules 2016, it incorporates the minimum qualification as prescribed by NCT norms from time to time, NCT from time to time, Rule 6.2 of the Recruitment Rules 2016 is intended to be incorporate NCT qualification that is relevant as on the date of recruitment, and as such, the provision had to be worded flexibly to accommodate changes that may be brought about by the NCT from time to time. In order to ensure a seamless adoption of amendments, modification, or variations prescribed by NCT from time to time, the rule adopts the standard legislative device or simply incorporating and referring to the minimum qualification as prescribed by NCT. Further, to ensure that the latest prescription of NCT should be made applicable for any recruitment, the rule also provides that qualification prescribed by NCT prevailing as on the date of publication of the recruitment notification must be possessed by the candidate. The intendment of Rule 6.2 of the Recruitment Rules 2016 is only to declare that the qualification as prescribed by the NCT and that are prevailing on the date of publication of the recruitment notice should be possessed by the candidate. The purpose and object of this rule is not at all to declare a cut-off date for obtaining qualification. We are in complete agreement that the clear stand taken by the board in its affidavit filed before the division bench of the High Court, in which the board clarified the position as under. The aforesaid notification dated 29/7/2011 laid down the minimum qualification for a person to be eligible for appointment as a teacher. The notification never stipulates any date of eligibility. In other words, and on and from which date such eligibility is to be counted and assessed is not specified in the notification. It can be the first day of January of the year of recruitment, it can be on the date of recruitment notification, or it can be the date of which the candidates is evaluated. At the cost of proximity, it is stated that the no fixed date for consideration of the eligibility is evident from the aforesaid notification of NCT. Now, that's the affidavit given by the Lord Board before the Honorable Division Bench. Having considered the matter in detail, we are of the opinion that the High Court committed a mistake. My dear Lordship, looking at something.
Yes, yes, read.
So that's the interpretation with regard to blood eligibility criteria of the board. Now, paragraph 21, Lord, is having considered the matter in detail, we are of the opinion that the High Court committed a mistake in interpreting the construing Rule 6.2 as provision prescribe some kind of cut-off date by which the time the minimum educational qualification must be possessed.
Yes.
This reasoning is contrary to the text of the rule. It is also contrary to the clear and unambiguous stand of the board. Board is changing terms in every recruitment process. The interpretation of Rule 6.2 adopted by the division bench is incorrect, and the judgment of this issue is hereby set aside. Now, the next paragraph would be, as I said, the all answers, the argument advised by Mr. Shannal has been answered in the Honorable Supreme Court judgment in Somen Park. That is the reason I am elaborately pressing the judgment before your lordship. The principle, the paragraph 22, the principles as regards the date by which the candidates for selection must possess the qualification as per the precedents of this court. We must deal with the argument of Mr. Shannal, Subhi Shannal and its senior counsel appearing on behalf of the respondent that as per the principle of law laid down by this court, that if the recruitment rule or the notification does not provide a date by which the minimum qualification must be possessed, the relevant date shall be last date for receipt of the application. This was the submission which is I am submitting before your lordship today. He relied on the judgment of this court in Bhupinder Pal Singh versus State of Punjab, formulating certain principles of determining the date by which candidate must possess eligible qualifications. So Mr. Shannal has also changed his stance and argued that the date of notification would be the date of last date to be treated, the eligible criteria should be treated on that. But that was not the view of the court. Neither this was the submission of Mr. Shanna. Today, for reasons known to him, has changed his views, changed his the issue regarding the date by which candidates for selection must possess the minimum qualification prescribed for recruitment is no more res integra. Apart from the decision of the court of Bhupinder Pal Singh referred by Mr. Shannal, there are many other precedents which were referred to and considered in a later decision of this court in Rakesh Kumar Sharma versus State of NCT Delhi. The relevant court portion has been quoted. There can be no dispute to the settled proposition of the selection process commence on the date of when applications are invited. Any person eligible on the date of submission of the application has a right to be considered against the said vacancy provided he fulfills the requisite qualifications. So these are well settled law. I need not have trouble with lordship. This has been reiterated, cited in many judgments, and even accepted by Mr. Shanal.
Yes. The date.
Now, while dealing with this aspect, the Tej Prakash which has been Pathak has also been relied on, which has been relied on. We are all aware that the rule of game cannot be changed. But the rule, the way it is being changed by the board, is the cause we are standing before your lordship.
Yes.
But as I said, the principle laid down in Tej Prakash Pathak, the rule of game cannot be changed in the midway. But I am not seeking any midway change. I am saying that you please publish my result or allow me to participate or you stall the process. Because you cannot deprive. And in a piecemeal, every time, every year, every occasion, according to your sweet desire, you change your terms. That cannot be the law. Law forbids you. Law mandates you. That's an Article 15A restriction on you, that you should abide by the law of the country. You being a statutory authority, you have failed to do so.
So what does this?
Now, Pathak also subject to the all consideration of the recent constitution decision delivering the judgment Justice Manoj Mishra, one of succinctly explained the legal position as follows. In various judicial pronouncements, the law governing recruitment to public service has been colloquially termed as the rule of game. The game is the process of selection and appointment. Courts have constantly frowned upon tinkering, tinkering with the rules of the game once the recruitment process commences. This has crystallized into an off-quoted legal phrase that the rule of the game must not be changed midway.
This
or
you did
after
not read. He has placed
But
it.
I'm not asking for even this judgment has no relevancy in my in this context because of the reason I'm not seeking any change of.
But supposing the date has not been given, then what is the proposition, settled proposition, that it will be the last date of application?
My lord, that's the judgment, Lord. Which that was the contention of Mr. Shanna also before the Honorable Supreme Court. That's the judgment, Lord, and subsequently, Lord. Bhupinder Pal Singh has also said, Lord, as well as Lord Rakesh Kumar Sharma has also said, Lord, that if anything is not, Lord, said anywhere, it would be the last date of submission of the forms. Now, that's the settled principle of law, Lord. Now, Lord, as I said, Lord, Tej Pukas Patok, Lord, has no relevancy in our case because of the reason, Lord, we are not saying to change any rules. Lord, we say that you please follow the rules. We say you please publish the result. You please allow us to participate in the proceedings. We are not saying change the rules because the change of blood rule of game would have been if you are relaxing something for me now by way of a subsequent notification to facilitate some other persons. If you change something, that is some, supposedly they come and say today that okay, there will be no interview, only on the basis of mark sheets, marks scored by you.
Fact in Soman Pal is separate and distinct from your case, since in that case there was a separate notification which says that the person who was pursuing will be allowed.
But here also, in my case, there are two notifications. As I said,
Two notifications are there, but the eligibility criteria in the notification given in the earlier, which was before the Honorable Supreme Court, in that,
yes,
including the appearing candidates.
Lord, your Lordship would kindly appreciate one aspect. The subsequent notification is in continuation with the earlier notification. So you cannot say that ends there. That ends there. The notification is in CC. So I say, not subject Lordship kind sanction, I say the second notification is the notification for recruitment because there your Lordship would kindly see the notification of November 19.
Yes.
Because there you invite applications. You say that you are going to one, two are distinct and different. One.
So as per your argument, it will be 9th December, which will be the last date.
Obliged. That is my argument before your Lordship, that it would be the last date of submission of the forms online on that particular. That is the reason, Lord, we have come before your Lordship that we should be declared pass or fail. Let the result be declared. So at least we will be able to understand whether I have a qualification to appear in the recruitment process. Now, you are withholding in one hand, you are saying that the last date is the date of notification. No, that cannot run concurrently. You have to take a decision that whether either you publish the result and declare me and that I have failed in the examination. So I'll not come before the court and say that kindly allow me to participate in the recruitment process. Because of you, I am not qualified. Your action is dependent on my right. That's the inaction, Lord, I have challenged in this writ application.
Which is the conclusion.
I'll just read, Lord, three more paragraphs, 25, 26 and 28. Because it has answered, Lord. Lord, I am on the initially, Lord, I thought, Lord, these are the factual background, Lord, I need to place. These are the, Lord, now, Lord, the Honorable Supreme Court has summarized everything and, Lord, given answer of everything. But kindly allow me to place three more paragraphs, Lord. The application of the interpretation and these precedents, Lends to the fact of the present case. We have already held that Rule 6.2 of the Recruitment Rules 2016 does not prescribe a date, not this is relevant, does not prescribe a date by which minimum qualification must be possessed. We have also upheld the stand of the board in this regard. It is in this context we must now consider the legality and validity of the recruitment notification dated 21st October 2022. We need for a close scrutiny of the recruitment notification is also to ensure that it is in consonance with the law laid down by this court. Paragraph 26, even as per the provision decisions of this court in Bhupinder Singh, the public employment must satisfy his eligibility requirement in terms of the date appointed by the relevant service route, and if there is no cut-off date appointed by the rules, then such date as may be appointed by the purpose of advertising calling for applications.
Yes.
Further, if there is no such date appointed, then eligibility criteria shall be with the reference to the last date appointed by which the applicants have to be received. Applications have to be received. Now, Lord, paragraph 28, Lord, is relevant, Lord. An important feature of this case is that the appellants were aggrieved by the inordinate delay in the conduct and completion of D.El.Ed course for the session 2020-2022, which was to be concluded by 30th June 2022. They invoked the jurisdiction of the High Court with a prayer for immediate declaration of their result in D.El.Ed, or in alternative, to direct the state government not to initiate the recruitment process pending declaration of their result. Lord, we are also, Lord, praying this similar relief and same relief before your Lordship, Lord.
Publish the results then. Why you are wishing?
Conclude your
Lord,
lordship.
the writ petition was filed by them at the earliest occasion, that is on 28/8/2022, without any delay. Lord, here, Lord, the notification comes in September. Lord, we come approach before the course, Lord, in the month of November. The learned single judge and Lord, by this time there was a hope that yes, your result will be declared. You wait. We are talking to board, the colleges, Lord, we are talking with the authority, and we have been given hope that your result will be published so that we can participate in the recruitment process. But till date, it has not been done. The learned single judge of the High Court did not take up the writ petition on merit. Had the learned judge dealt with the writ petition on merit, one of the reliefs as spread by the appellant could have been granted. That is, either that the result would have been directed to be declared immediately, or that the recruitment would have been postponed. I have also prayed for stay of the recruitment process in absence, Lord, of if they are not publishing the result of my Part 2 examination. But there I made out a case, Lord, the Honorable Supreme Court observes that either you declare the result or you stall the process, because you cannot throw me out of the zone of consideration only on the ground that you have not passed, did not get the degree certificate. Your Lordship has rightly, not on the last occasion, has given an example that the students who appears in entrance examination like MBBS and NEET and JEE previously in our time, a appearing candidate was allowed to participate in the entrance examination, and if he is not passed, his qualification is his candidature will automatically be cancelled. And it is not that you are appointing me. You are allowing me, Lord. You are allowing me to participate in the recruitment process. There are processes how the recruitment would be proceeded. There are filling up of forms, scrutinizing, then Lord, the numbering part, then there is interview, then there is aptitude test. There are many things. The process will continue and I'll miss that. What is the reason I have come before your Lordship? Because I'll miss that opportunity. For your action, I cannot miss the opportunity. The equity or right created in my favor, you cannot deprive. That's the case before your lordship. Now, Lord, that the result would have been directed to be declared immediately, or the recruitment would have been postponed. Instead, the learned single judge disposed of the writ petition on the basis of a submission made on behalf of the board, proposing the equitable solution for resolution of the dispute. On the basis of the submission of the board, the High Court permitted candidates such as the appellants to be given an opportunity to participate in the recruitment process. The learned judge of the High Court was not compromising on the standard prescribed by the appointment. It is nobody's case that unqualified persons will be appointed. The direction of the learned single judge enabled candidates as such the appellants who were at the stage of completing the course of to participate in the selection process, and they would have been appointed only upon attaining the prescribed qualification. Well, Lord, I qualify. Lord, I'll be appointed if I qualify the thing. If I'm competent and if I'm scoring and coming with the zone of consideration for appointment. The appellants who applied as per the recruitment notification dated 21/10/2022 obtained their course completion certificate on 29/11/2022, and their final results were declared on 30th December 2022 after the recruitment notification. The interview commenced in December 2022. And when the process was to be taken to its logical end, the division bench passed the impugned order, setting aside the direction of the learned single judge by interpreting the 6(2) of the recruitment rules 2016 as if it prescribed a cut-off date for eligibility. And ultimately, Lord, the facts of the case reveals a rather extraordinary situation where the board and also the High Court ought to resolve the problem that had arisen due to late conduct of the B.Ed and D.El.Ed examination immediately after the COVID-19 pandemic. We are of the opinion that there is no illegality and arbitrariness in the actual recruitment notification dated 21/10, the subsequent notification, and the recruitment process commenced under the relevant rules and also as per the direction of the learned single judge of the High Court disposing of the writ petition. It is important to note the recruitment notification dated such and such was not challenged by anyone. And Lord, the Honorable Supreme Court, Lord, reiterates, Lord, the eligibility qualification on the date of the last date, Lord. And in this way, Lord, the earlier recruitment process of 2022 was affirmed by the Honorable Supreme Court. Lord, the issue was set. The genesis and the originating part was, Lord, of non-publishing of the result of the D.El.Ed candidates. They were given, Lord, the board consented in the earlier recruitment process that yes, we'll allow them, even pursuing candidates. Lord, here to Lord, we have completed the course. In the earlier occasion, they have allowed the pursuing candidate also, part 1 only. Part 2 examination was also not done. So I say, Lord, before your Lordship, that the earlier occasion also, Lord, this question traveled to, Lord, pertaining to the same recruitment process. And your Lordship has seen the observations made by the Honorable Division Bench as well as the Honorable Supreme Court, how the rules of Rule 6(2) has been interpreted, and how the candidates whose result has been withheld, has been accommodated and allowed to participate in the recruitment process. Now, Lord, it was obviously the Honorable Supreme Court has held, Lord, while deciding the issue whether their participation was legal or illegal, has also said the option before the Honorable Single Judge was either directing them to publish the result or to stall the entire selection process. Because as I said, Lord, I have made out a case by this time before your Lordship that I have completed the course. You are not doing it. You are obligated to complete it by June 31st. We are in December already. 6 months has changed. If you take, Lord, the words of Mr. Shannal, that 7 months, we are already in 7 months. And on previous occasions, Lord, also, Lord, there are other recruitment, other, Lord, examinations of D.El.Ed, Lord, they have passed, Lord, they have published results in the month of first week of December also. Lord, this action of withholding result, Lord, is an act of arbitrariness for which, Lord, we have been disallowed to participate in the recruitment process. Lord, the Honorable Supreme Court has ultimately discussing everything, Lord, has upheld the order of the Honorable Single Bench and set aside the order of the Honorable Division Bench.
But taking in consideration Bhupinder Pal Singh, Rakesh Sharma and Tej Prakash, it holds that the qualification must be possessed
As
as
per the
per
prescribed.
those prescribed in the rules.
Now, Lord, the rules, Lord, Your Lordship, that's the reason, Lord, I need to, Your Lordship would kindly take, Lord, paragraph 29 once for a second.
Now 6.2 says that it should be possessed on the date of advertisement.
But that has wrongly been interpreted, Lord. Your Lordship would kindly take, Lord. Now, Lord, it has to be read with, Lord, paragraph 21 also, Lord.
Paragraph 29.
29 and 21. Lord, it says, Lord,
How do you interpret this? Suppose qualification must be possessed as per those prescribed in the rules. Rule says on the date of advertisement. Then it says or the notification. Rules or notification. And in absence of both, if the rules is silent, the notification is also silent on which date it is to be possessed, then we go by reference to the last date appointed for receiving it.
now, Lord, here in that case also, Lord, the final result was published in the month of December. That was also taken into consideration and they were allowed to participate in the recruitment process. That is what, Lord, my contention is.
But the proposition, do you find that in the facts and circumstances of this case, if 6.2 says that on the date of advertisement, I accept your analogy that the date of application will be November 19th, November 2025, which is the subsequent application which says that the last date would be 9th December. So in continuation to that, the second has come. In the month of November also, they are not possessing that. But 6.2 says that it will be possessed on the date of advertisement. And after considering Bhupinder Pal Singh, Rakesh Kumar and Tej Prakash, the court says that in the absence, the rule is silent, the notification is silent of the date on which the candidate must possess the degree. In that event, the last date fixed for receiving the applications will be the cutoff date on which the applicant has to possess that degree. So, how do you interpret this? That's why I told you the facts here is they have completed 2 years course. The results are awaited. In the earlier one, they allowed part 1 who has completed part 1 to participate in the process. Correct. So starkly there is a difference in the facts of the earlier case and this case.
I understand. Look, I am on a better footing than of them.
Correct.
Because of the reason that
your only lacking is that the results have not come out. Well, so far as the date of concern, that date has been in 6.2, it has been stated that it should be as per the advertisement, date of advertisement.
No, my lord, your lordship would
And the court also says that if it is absent, then we can take that date. That the last date of receiving application can be applied in your case.
No, my lord, your lordship would kindly take note of lord which has been placed in paragraph 3. You-
No, no. Mr. Sun only placed that.
may
Yes, yes.
paragraph 20 has your lordship is looking at 6.2. That is also quoted in the judgment. আগে recruitment notification টা দেখাচ্ছি।
When did
I just
2 has been amended on which date?
December 2020, 22nd December 2020.
ডেটটা আমি বলতে পারছি না।
হ্যাঁ,
হ্যাঁ 22nd December 2020.
But the rule 6 which has been quoted and the rules which has been given here, both are separate. I find the language
Yes, yes, unamended, amended.
which one?
in the judgment of the Honorable Supreme Court.
Paragraph-
So many.
Paragraph
Yes,
3.
yes, yes, paragraph 3.
The candidate shall possess the minimum educational and training qualification as prescribed by the National Council for the Teachers Eligibility Education
As on the date
prevailing
of
as on the date of
Yes, yes,
publication
sir.
of the recruitment notification. It's there. That has been interpreted. That was my case, Lord. I have said that has been taken care of. Now, Lord, I will just, Lord, show the earlier notification. That is at page 624 of my writ application.
But what about 31?
Lord, I'll come. That is
Paragraph 31, just I have indicated.
the cutoff.
What about 31?
Your Lordship would kindly take note of the earlier notification for a second. Kindly. Page 624.
এই কটা বিল ইউজ করলেন?
আর যাবো না
ছেড়ে দে ক্রিমিনাল, বেল দিয়ে কিছু হবে না, দেখেছিস রিটে সবচেয়ে পয়সা বেশি। সিভিল
Your Lordship would kindly see the earlier notification, Lord. What is the Lord? Well, 3B. Your Lordship would kindly take.
How will it better your case?
My Lord.
You just tell me what should be the date now. Yeah, the judgment which you have referred, this concluding portion.
Your Lordship would kindly take note of 624 3B.
Unamended is there.
This is both.
Same, Lord. This is same.
না 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 ওইটা একটু আরো অন্য কিছু।
Rules টার কথা বলছি।
হ্যাঁ।
Rules এ Lord, that particular was not there.
But your lordship will find page 117 of the spiral.
সে তো Supreme Court judgment
Matlab, this was rules of 2016. March 2, 2016. Qualification 6.2.
Yes. He is referring to 3. Mr. Ahmed, you are referring to?
Lord, 624 3B. The candidate shall possess the minimum educational and training qualifications as prescribed by the National Council for Teacher Education prevailing as on the date of publication of the recruitment notification. That was the first notification, Lord, which the Honorable Supreme Court has taken note. There subsequently, Lord, in 21st October, and says, the Honorable Supreme Court says, since there is a publication and disclosure of vacancies and mode and modality has been set, so that is the recruitment notice. Now, Lord, we need to read, Lord, along with this paragraph 21 for a second. The Honorable Division Bench, Lord, held otherwise, but the Honorable this has been discarded by the Honorable Supreme Court. Having considered the matter in detail, we are of the opinion that the High Court committed a mistake in interpreting and construing Rule 6.2 as a provision prescribing some kind of a cut-off date by which time the minimum educational qualification must be possessed. This reasoning is contrary to the text of the rule. It is also contrary to the clear and unambiguous stand of the board. The interpretation of Rule 6.2 adopted by the division bench is incorrect, and the judgment on this issue is hereby set aside. Because the previous paragraph not have placed is blood, the previous paragraph blood have shown blood is the notification of the NCT, and they are blood. I'm sorry, blood. The affidavit blood filed by the board.
প্রবলেম বলতে সুপ্রিম কোর্টের জাজমেন্টকে হাইকোর্ট মেনে নিতে পারে, তো সুপ্রিম বলে মানতে হবে। সুপ্রিম সুপ্রিম কোর্ট দিলেও সুপ্রিম বুঝতে দেওয়াটা প্রবলেম না, প্রবলেমটা অন্য জায়গায়, লটা খাই।
Otherwise, you are celebrating.
This notification of 29/9/2020 is akin to blood September notification.
আর কি আছে ইয়াতে?
You have given a copy to Mr. Sannan?
The judgment, Mr. Shanal appeared.
Might
I have
be, he
given-
has appeared in many cases. Give him. Page 21 of the judgment.
Niche number.
So if you start with page 20, then it will be clear. Now the intendment of Rule 6.2
Just
yes,
Hmm.
is to declare that the qualifications as prescribed by NCT and are prevailing on the date of publication of recruitment notification should be possessed by the candidate. Now the purpose and object of the rule is not at all to declare a cut-off date for obtaining the qualification. Now what was the affidavit and what was the declaration before the Honorable Supreme Court by the board regarding certain interpretation of the date of publication?
date of publication.
It has been set out.
Done. Your lordship quoted portion.
Yes,
May I read out with your lordship?
yes.
The aforesaid notification dated 29th July 2021 lays down the minimum qualifications for a person to be eligible for appointment as a teacher. The notification never stipulates any date of eligibility. Malad, this is Malad, pause there for a moment. This is the notification of NCT. NCT is not the recruiting authority. NCT is the academic authority under the Right to Education Act. His job or exercise is only to lay down the qualification, minimum qualification, nothing else. How can he prescribe the date? Can he prescribe the date?
That is what the Honorable Court is
With
saying.
all respect, Malad, may I tell your lawsuits? Judgment of the Supreme Court is the supreme. We have to abide by that. But your lawsuits in the facts of the case, whether this judgment goes, I will make my submissions, your lawsuits.
No, Lord, I know, Lord, like previous occasion, Mr. Shanal said that I have not said anything about it. Again, he will come and say, no, this is the first notification and we should be abide by the, we will stick to
Don't
the
presume my
September
submission.
notification.
So you conclude
No,
your argument.
because of the reason, Lord, I failed one bus, but I do not want to. আগের বার টেটটা না বললাম না, আপনি এসে এমন বলে দিলেন যে আমাকে এতক্ষণ ধরে এক্সপ্লেনেশন দিতে হচ্ছে। দ্যাটস দ্য থিং। না বললাম দিস ইজ সেটি লার্ন ফ্রম লর্ড, দিস ইজ ইন রেসপেক্ট অফ হ্যাঁ
কালকে কোথায় ঠিক তো তারিখ তো
আরো কিছু বলার থাকলে বলো।
অবভিয়াসলি আরো 3টে পয়েন্ট বলা হবে।
সেকেন্ড হাফে বলবি
আর সেকেন্ড হাফ নয়,
প্লিজ আমাকে
সেকেন্ড হাফে
আমি কালকে আসতে পারবো না। না তুই তাকে তবে শামীম বলবে, বলিস না আমি পারবো না, তাহলে তাহলে সোমবারে ফিক্স করে হ্যাঁ সোমবারে করে দেন ভাই।
স্টেট আছে
মুশকিল হয়ে যাবে আমার পক্ষে, আমার পক্ষে মুশকিল হয়ে যাবে। আমি শুনে নিয়ে তারপরে তোর বল না, তারপর যা খুশি আমার পাঠাতে বল না। আরে ঘরে ঢুকবার মানে এই মামলাটার জন্য আমারটা অপোজ করবে, ও করে না কি করবো, ওরটা অপোজ তো না কালকে আসতে পারবো না।
in answer
এই ডেটটা ভুল হয়ে গেল, বুঝলে?
in answering Lord
জাস্ট মিনিট মিস্টার
Malad,
ইয়েস,
শীতকালে পড়া যায়। Now, Lord, so far, Lord, the other issues, Lord, these are the with regard to Lord, I have made my submissions with regard to Lord TET and Lord the cut-off date and Lord the parity with regard to the earlier recruitment notification and the consequence Lord ended up to Supreme Court. And I say, Lord, I may be looked into in that perspective that there cannot be any cut-off date for qualification, and it will be on the last date of recruitment notification. The recruitment notification is to be considered as Lord the 19th November 2025. And the other point, Lord, which has been raised by my senior friend is that, Lord, some of the applicants here in the writ petition is party, Lord, in a different writ petition. Lord, I completely, Lord, bow down before your Lordship, Lord, that the prayers with regard to, Lord, the relief, Lord, sought in that writ petition and this writ petition are two distinctive cause of action. The cause of action in respect of that particular writ petition is otherwise, and here is the immediate cause that the recruitment notification has been published and we will be thrown out of the jurisdiction since our result has not been declared. So, Lord, this there is no, Lord, reason that all the same cause of action, Lord, we have come before the court.
But what is the prayer in the earlier?
The prayer in the writ petition, Lord, and here may I just read, Lord, the prayer of the writ petition, Lord, on the last occasion, Mr. Vishwas has handed over to your Lordship, Lord. Lord, that was, Lord, the prayer, Lord, the entire writ petition and the pleadings, Lord, when in the writ petition was for the purpose of uploading the data, for the purpose of automatic filling up of forms, because the West Bengal Primary Board, Lord, maintains a data in respect of individual candidates, like when he has passed TET, when he has, what is the score, what is his name, what is his address. Now, Lord, that was for, Lord, আচ্ছা আচ্ছা তুই জেরক্স করে দিলি
না জেরক্সটা দিয়েছে কিনা আমি জানি না।
So that was, Lord, for the purpose of, Lord, the prayer was for uploading those datas, the D.El.Ed degree data, TET data and everything, Lord, so that, Lord, nowadays what happens, now the moment, Lord, I put my, Lord, mobile number or my name, it automatically, Lord, like the way it automatically in Google form, Lord, the moment we say autofills, Lord, comes, this is the way the board maintains a data. Lord, I can place, Lord, the pleadings in the writ petition. Lord, I'll just, Lord, read paragraph 3, Lord, while the jural relationship has been explained, and then paragraph 3, Lord, speaks about, Lord, the jural relationship, and then, Lord, paragraph 4, the writ petitioner stated that the West Bengal Board of Primary Education published a notification on 29/9/2022 for conduction of, Lord, TET and such and such. In that said notification, it is clearly stated that only those persons who have acquired the academic and professional qualifications specified in such and such, also with such and such, it is also stated in that the candidates who have required minimum academic qualifications after the date of publication of the notification will not be entertained for appearing in TET and such. Now, Lord, then paragraph 5 says, Lord, we say that we are eligible and appeared, and then paragraph 5 says the petitioner said the petitioner have all requisite qualification had requisite qualification to appear in TET 2022 examination conducted by the such and such board. All the petitioners have B.Ed degree, and at present all the petitioners are pursuing candidates of D.El.Ed session 2023-2025. All the petitioners have all requisite qualification to appear in TET 2022 examination and qualify in the said examination. All the petitioner possess the eligibility criteria of B.Ed as per advertisement notification, and they are eligible candidates. All the petitioner, no, basically this was the effect plot sought in terms of plot the judgment delivered in Devesh Kumar. And your lordship would kindly Devesh Sharma. At Devesh Kumar judgment sanction.
CF.
The paragraph.
Prayer F. Prayer F.
Declaration of TET. That blood has been pointed out by Mr. Shannar. Declaration declaring that the petitioner all are eligible TET 2022 past candidate to participate. Lord, your lordship would kindly take note to participate in any future selection process. That is what Lord, we are seeking, because of the reason, Lord, we have qualified to the extent of D.El.Ed degree.
No, in the present writ petition, you say that you have qualified TET only because the results in D.El.Ed has not been declared, so that be published so that they can participate. The other writ petition, you seek that you be declared as a valid candidate TET 22. The person who seeks for declaration, he or she himself is not clear whether it is a valid TET 2022 or not. So there was no purpose for the petitioners, as he has indicated, that to seek for a declaration of TET 2022 when he himself knows that he has qualified. Lord, what was the purpose of seeking a declaration from the court?
Seeking, Lord, because by this time, Lord, your lordship would kindly see the date. By this time, Lord, there were 2 writ petitions pending. There are, Lord, the board himself, Lord, has issued a notification which Mr. Sannal has, Lord, referred. So, Lord, we sought, Lord, a declaration from the court, which is also, Lord, integrated, Lord, issue before your lordship also. So, Lord, the question of
along these candidates, for the sake of argument, will make the earlier writ petition where a direction has been issued for filing affidavits by the board,
along with other reliefs, Lord.
This was the primary writ petition of this writ petition, the earlier one.
The earlier one, Lord, was. Well, kindly give me a second. Mr. Shamim appeared in that writ petition.
I give the report file করেছিল সেখানে বলেছে they are eligible. Okay, my point was suppression. Your losses need not go into this.
No, Lord,
By prayer is a suppression.
no, Lord, I say,
One
Lord,
for
subject lordship can sanction.
disclosing.
The cause of actions are different because they are, Lord, we are only seeking, Lord, Lord, uploading of documents.
So the same prayers are coming over here.
No, it's not, Lord, the prayers are different. Lord, I'll just read paragraph 10, Lord. The petitioner states that the West Bengal board.
Ahmed, the couching of the language is different. In that case, you said of uploading, your prayer is for publishing. Until and until the results are published, there is no question of uploading.
Not result. The earlier writ petition was not declaration of result. That was only for the purpose of, Lord, uploading, Lord, informations in the website. Lord, may I just Lord, read it. Your petitioner states that the West Bengal Board of Primary Education on 4/11/2022 published a notification for online application of teacher eligibility, wherein inter alia stated as follows. Now, Lord, we have said certain things, and then, Lord, we prayed for. On the day the petitioners are, Lord, we declare that we are eligible candidate, Lord, in TET. We do not say, but on the declaration, we wanted to participate in the selection future process. Now, the Lord, this is first stage. Lord, kindly allow me to clarify. The first stage is that you allow me. Now the selection process has started. Now I come and say, you allow me to join. Because that was, Lord, a preparatory, Lord, writ application, because their data were not available in the website. And the main issue, Lord, we also would kindly take note of it. The initial issue was the TET was with B.Ed. Now this writ petitioners wanted to incorporate their D.El.Ed degree in the database. That was the writ petition. The purpose was, Lord, a preparation to upload the document with the board so that we can take participate. Your Lordship, if your Lordship sees paragraph prayer F, the paragraph prayer F is to declare TET to participate. Because
Give a copy of that report.
but I
That's all.
That minute. Blood, when we go to blood, the fill up the forms, blood, when you put, as I said, blood, I just stop. When you fill our name, number, or blood, other data, automatically it takes from the database of the blood board. It is autofill, so that nobody can tamper and no individual. The photograph also comes.
Yes.
It's not that blood, the entire thing is autofill. The moment the code is or TET number is given. So for that reason, Lord, we wanted to upload our degree with regard to D.El.Ed. Lord, why this is being done? Because the earlier notification of 18 June Lord notification is all about that if a candidate is Lord allowed to participate in the recruitment process, he has to undergo a bridge course. Now we do not require a bridge course because already we are having a D.El.Ed degree. That we wanted to include. That was the purpose of the writ petition.
No, D.El.Ed, you're not, right now you're not possessing it. You have completed.
The database is not taking. So Lord, we also wanted to inform.
ভুল বোঝাচ্ছি
Sir,
I
আপনি
can
দুদিন
clear.
ধরে আপনি দুদিন ধরে বোঝালেন
ডাটাবেসটা
yes
That is-
that's
that
the
is
thing. Lord, may I just read the first prayer, Lord? Your Lordship would kindly see, Lord.
Okay,
First
I will
prayer.
see your prayer and tally with the present writ petition.
My Lord. The first prayer is, Lord,
You say that your earlier writ petition was in anticipation that in future recruitment you will be allowed
Obliged.
to have a blanket order that in future if any recruitment
Deep
process is taken, in the meantime a recruitment process is taken up, so you come with the
deep
subsequent.
obliged. Not bow
This
down
is your
before-
case.
That's the blood purpose.
Okay.
Because the prayer says alter teacher training data of the petitioner in West Bengal such and such.
That's all.
My Lord, yes. These are the things, Lord. I just missed one point. One point because of the reason, Lord.
আমি বলিনি যে তারপর
The recruitment notice is concerned. The recruitment notice is concerned. I'll accompany, sir. The recruitment notice is concerned. The new batch of candidates wanted to move the writ petition before this honorable court, challenging Lord the notification of 20 September 25. Mr. The board comes and says, no. I'll just read. The Learned Counsel appearing for the respondent primary board has rightly pointed out to the court that the notification dated 25/9/2025, on the basis of which the petitioner's pray for liberty is not a notice calling for application. Clause 9 of the said notification is relevant wherein it has been stated that the schedule for opening application portal and submitting the filled in application form through online mode will be notified later. So they cannot come and say that this both. So Lord, they cannot come and say that this is a recruitment notification. Lord, this is the observation, and based on the submission, the writ petition was dismissed.
রিক্রুটমেন্ট
So-
নোটিফিকেশন নয় বলছে
ভেকেশনে
Lord, in all probabilities, Lord, the petitioners before your lordship being Lord the candidates who have completed their D.El.Ed degree, Lord, they cannot be deprived of to appear in the recruitment process.
very next matter is
Respect to item number,
the very next
with
matter is
respect
mine.
to item number 211. My lord, only thing, my lord, before hearing the board or the added parties, we are also sailing on the same boat. My lord, let us complete our argument.
Otherwise,
Thereafter, it will be a combined reply. Otherwise, it will continue.
my lord, otherwise, my lord, we will be prejudiced, my lord. Kindly, but otherwise, my lord, we will be prejudiced, my lord.
Your
If
lordship,
it is
remember, kindly
decided,
will not take, my lord, more than 10 minutes,
I
my
will
lord.
take, my lord, just 5 minutes.
Last but not the least, Lord, I've missed one point. Lord, your lordship, Lord, I've gathered, Lord, your lordship has already allowed, Lord, the
Pursuing
special educators, the pursuing candidates. Lord, that order, Lord, I'm not.
That is separate. That
My lord, I think, my lord, after recess, my lord, I will resume.
My lord, only thing, let us start, my lord, because otherwise, without hearing us, there is no point. We are also sailing on the same boat, little different. We are not TET 2022. We are TET 2023. We appeared in TET as a pursuing candidate. We qualified it. Now, immediate. My lord, this is the fact, my lord.
My lord, if
Is
that
why, my
is
lord,
disposed of, my lord,
request
our matter will be prejudiced, my lord. My
that
lord,
is why
kindly
we
hear me
base
because
our
Mr. Sannal,
thereafter they will.
my lord, Mr. Sannal swing in both ways.
Mr. Ghosh has no cause of action.
Mr. Sannal sometimes appeared in behalf of the petitioner to take their side, they take us the petitioner to protect their right. The board is selling to protect Mr. Sannal's personal client right. I will show it from the order itself. Yes.
Personally, my lord.
No. I report. I will show the board order, my lord. I will show it. I will show it. I will show it. I will show it, my lord. My lord.
Most client,
Yes.
they are eligible, they are appearing.
Because of that, they wants to protect someone's right. They wants to restrict the selection process to some of the candidates, my lord. They wants to reduce it. That's the point, my lord. Our endeavor is that, my lord. Because of that, my lord, why? What is the matter about? But this matter about that, my lord, board ought to, my lord, board ought to publish the result. Why they not published it? Because of that, my lord, they delays this 6 months to accommodate those candidates who are their favorite candidates. I will show from that order ballot itself, my lord. Yes, my lord, kindly give that, my lord. Otherwise, they want, my lord, they come with that this matter, my lord. They want that only one matter, not that, my lord. Our right will be infringed, my lord. I will place it, my lord. Thereafter, my lord, pass the order.
My lord, we will hear it at your lordship. Kindly hear me for 10 minutes. I will adopt Mr. Ahmed's submission. Only I will add three additional points. Thereafter, my lord, I will not take much time. I will adopt primarily Mr. Ahmed's submission. Will only take
the date to 2025 pass.
2023, not 2025.
Is it the same 2022 date pass? But who are they? I have challenged the candidature since they are the date qualified.
But here be at least, my lord, 10 minutes, my lord. Thereafter, my lord, votes.
I will demonstrate your lordship. My senior is there. I will demonstrate your lordship. They are not even pursuing when the date was conducted. So the matter and the causation are different. So the reasons are different.
My lord, this matter is all about the pursuing that candidate who completed their course, my lord. Till date, the board not, because the board conduct the selection process, board conduct the D.El.Ed, and board conduct the TET. The same authority conduct it, my lord. So, my lord, they consciously delayed it, my lord. I will show it, my lord. They consciously delayed it
Kindly hear us, then hear
to restrict this selection process to some of their favorite candidates, my lord. That's the point.
This would be an unending process, Lord, if people.
Do not be, but if they publish it today, what is the impediment to publish the result today? Because the result, that is not their business. They who are the addition of party, they wants to reduce the competition. That's their endeavor. What is that? And for board work in their benefit, to reduce their benefit. But in June 2025, the course is complete. The NCT guideline and a notification is very specific. Course is 2 years. The student can do it for 3 years, my lord. It is student prerogative, not the authority's prerogative. Authority now extended that time to accommodate their favorite candidate. That is their purpose. Do not publish the result, my lord. That is their whole purpose. That is their whole purpose, my lord.
thing is before the court. Now let me come back.
Yes, my lord. My lord, kindly hear us. My lord, kindly hear us, my lord. I will demonstrate from the court record
My
itself.
humble request, your lordships, kindly hear me first. Let them hear all.
how will we place our.
I will not come back to argue again. Let them place thereafter if your lordship so desires. But my humble submission is a independent writ petition decide on its merit. If there are different facts,
Board can't say so, my lord. Board can't say so. I believe Mr. Sannal's, my lord, they appear on behalf of the Article 12 authority, not on behalf of the private party, my lord. They act, the board work in the instances of a private party.
Why? How? I am
Well, my
defending
rights,
case.
my rights is infringed, my lord.
To
For
do
both,
it
for both,
after
everyone
that.
is similar.
What
But
is your difficulty if your matter is taken up separately?
my lord, difficulty is if the order passed, my lord. If the order passed, it will harm me.
If the court asks you to argue your case separately and Mr. Sannal to reply separately, what is it?
Then I have no.
Then, my lord,
What is the difficulty?
that's the my point, my lord.
My lord,
What is your
Hear us.
that is what is following.
Wait, wait.
What order?
My lord, that is
Go
what
down,
following
my lord.
from your lordship, that your lordship will hear it separately. and
Yes, yes.
Channel.
You make
I have
I-
submission separately,
we have
let me
problem.
come with a
My
separate.
lord,
That's my
tomorrow,
submission.
Then to any date, my lord.
at 10:30, my lord, Mr. Mujumdar is leading me that item 211. My lord, I have
Mine is the 215, my lord. Then, my lord, 10:30, my lord. Tomorrow.
না না আজকে আর তাহলে কালকেই হোক, ঠিক আছে
আজকে তো হয়ে যাবে
না
আজকে হবে না, কাল হবে না।
211 and 200.
My lord, tomorrow I will not be available, my lord.
Okay, my lord,
for my
Monday
personal
we will
reasons.
give reply.
Let them conclude it. I will give the reply.
But make it short, huh? For 3 days, I am hearing this. Mr. Ahmed first started, then he made his submissions. After that, again, today, Mr. Ahmed has. If this continues, then we'll cross the limits.
My lord, that
Ah.
is why, my lord, we are saying
What you
after
do
recess,
is, since one matter has been heard, you were in court, you place your case separately. What are your points? Let Mr. Sannal reply to that, as well as if any other party is there.
Yes, my
Yes,
The
yes.
respondents will make their reply.
tomorrow at
Correct.
That's
Tomorrow, Mr. Sannal, in respect of this, you will continue in second half.
no, second now. And I will finish my lord as soon as possible.
Okay.
then, my lord, next
Because your
time
lordship has
tomorrow,
dealt with
211
elaborately all that
tomorrow,
order.
give our points.
211 and 215 tomorrow.
Tomorrow.
Fine. 10:30, my lord, kindly, otherwise
আরে
it
বাবা,
will
বলুক না ওদের মামলা, ওরা বলতে ক্ষতি কি? পরে আমি বলে
Which
দেবো।
one?
211 and 215, 10:30 tomorrow.
Okay.
দাদা এটা শুনে নিলেন ডিপলি